right, well, good afternoon, everyone, and welcome to today's Privacy Watch 2026 Key Risks, New Laws, and What to Watch webinar. We're going to give folks a few seconds here to get into the active session and allow time for late joiners to pop on. As we're doing that and folks are getting engaged, today's webinar is really to try to cover some key concepts and areas of risk that have emerged over the last year and that we see coming in 2026. A lot of states have, we have new comprehensive privacy laws, we have amendments and changes to existing ones. There are lawsuits popping up, feels like almost every day, enforcement actions, all kinds of sources of new guidance, requirements, and risks that we want to make sure are on your agenda going into this year. A couple pieces of housekeeping before we get started. First, the recording today will be available in about a week and hopefully next week in case you got to pop off early or you want to recommend it to a colleague. That will be on our website. Also, if you have any questions during today's session, please put those in the Q&A box within the Zoom system, not the chat box. We are monitoring the Q&A and we will try to get as many of those questions answered as possible. I'm Josh Stevens, a partner here at McMurray & Schuster. I'm joined today by my partner, Nick Whisler. We will be your privacy Sherpas this afternoon. As always, we couldn't have a legal webinar without a disclaimer. So just as a reminder, this is an educational webinar. It is not legal advice. Facts really matter when it comes to all things privacy. And so we're going to be talking about concepts and generalities, some of which they might be directly applicable to your situation, but your situation may have facts that could change the analysis. So always talk with your counsel, which maybe is us, maybe someone else, before acting on anything you see today. Also, just briefly, we don't recommend the use of AI note takers for this webinar. A lot of what we're going to be talking about has nuance that we find those note takers sometimes miss. So we recommend you go a little old school and actually take notes yourself during today's webinar. So let's get started with just kind of a lay of the land, where we stand today. There are, depending on how you count them, about 19 states that have comprehensive state privacy laws. Most recently, Indiana, Kentucky, and Rhode Island laws came into effect on January 1st. And there are no, at least at this time, other comprehensive state privacy laws that have been passed waiting to come into effect. As you can see on this map here from the IAPP, the International Association of Privacy Professionals, which tracks state privacy legislation, there are bills popping up, and those are the states in blue at various stages of consideration during the new legislative sessions. So it is possible that we may get some new state privacy laws this year or further amendments to existing laws. It's also possible that states may hold back a bit and wait to see if a federal privacy law comes out. There's been a lot of discussion around that, but not yet a lot of action. So the states are still where most of this is occurring, but we'll be interested to see what happens at the federal level. And when we're thinking about comprehensive state privacy laws, the first thing that we always do when working with a client is to determine whether the law actually applies to them or not. And we'd like to highlight two changes or developments in applicability, that might be a better way to phrase that, that maybe you've missed or has flown under the radar a little bit. And the first is Connecticut. Connecticut passed several amendments to their privacy law that will come into effect July 1st, 2026. One of the most significant changes is they have lowered the applicability threshold. So beginning in July, if a business processes 35,000 Connecticut consumers' data, the Connecticut privacy law will now apply. This is down from the prior standard of 100,000, which means smaller businesses may now be pulled into the scope of the law that otherwise didn't meet that fairly high threshold. Interestingly, though, if the business processes sensitive personal data or it sells personal data, then it doesn't, all you need is one consumer. You don't need to meet that size threshold. And we see this as potentially capturing a lot of small businesses who even wouldn't necessarily meet the 35,000 consumer threshold, but because they either sell data or they collect any type of sensitive personal information, now will come within scope of it. So that's something to keep on your radar. The second one is Rhode Island. Now, Rhode Island's privacy law came into effect January 1st. And for most of the law, there is a size threshold similar to what we see in other states based on how many consumers' data the data controller processes. But there's one section, this is 6-48.1-3, which relates to a website disclosure obligation that applies to any commercial website or internet service provider, and it does not have the same size threshold. In fact, it has no size threshold. This is significant because that website disclosure obligation is not only about the categories of PI collected, which is a pretty standard disclosure, or also giving an email address or other online mechanism for a consumer to get a hold of the business, which is also pretty typical. But the business has to identify third parties to whom it has sold or may sell personal information. And we are seeing a lot of clients who are impacted by this requirement, even though they're larger businesses, so there was no debate about a size threshold with them, because having to actually list in the privacy policy the identity of the third parties to whom personal information may be sold is not only very burdensome, but it may also reveal information that the business normally would like to keep secret, right? Essentially, their client list. They might want to keep that secret. And so that is an issue, and Nick's going to talk about this a little bit more in terms of privacy policies, but it also then bleeds over into applicability. Now, I will say with Rhode Island, as you see on the screen, there are other exemptions based on types of data or type of entity that do apply to this obligation. So for our healthcare viewers out there who are subject to HIPAA, or for financial institutions who are subject to GLBA, you don't really have to worry about this, but most other folks do. And as I said, this is something that really impacts the privacy policy. So Nick, why don't you tell us a little bit more about the privacy policy impacts this year?
Yeah. So I think as far as kind of getting through some of the updates that we're going to cover today, what we tried to do is break them down by topic. So, Josh went through some of the changes, right? We've got updates in Connecticut, you've got new state laws coming on. He mentioned at the beginning that there's been enforcement activities, private lawsuits, et cetera. And so we're going to cover all of those issues on a topic by topic basis, starting with the privacy policy. And so this is it's kind of like a checklist that businesses can use to see if their privacy policy has been updated in accordance with some of these new requirements, to see if there are tweaks that need to be made based on some of the regulatory activity and guidance that we've seen out there. And so the easiest one, in the first bullet at the top really relates to those new state laws. That's the easiest thing from a pure privacy policy update. Maybe your privacy policy already extends rights to consumers in all states. If so, no change needed. Maybe you have a section that says if you live in one of these states, then you have certain privacy rights, and here's what those rights are. If that's the case, you'll just want to make sure that you have updated that list of states to include Indiana, Kentucky, and Rhode Island, which are the three states whose laws went into effect this year. And probably a good idea to go back and actually cross-check against some of the other states. We've actually found when working with clients that maybe they added California at the beginning and a handful of states as they came in, but they might have missed one just because there's been new state laws, and they're not always at the beginning of the year. It might be July. There's some in October. So just check your list of states and make sure it covers the 19 states that Josh had mentioned on the previous slide. Another thing that you want to be checking in your privacy policy for And this one actually stems from updates to California's regulations. Um, there was some language in there previously about disclosing the categories of third parties to whom you make a disclosure for a business purpose. And the definition of business purpose really aligned more with disclosures made to a service provider. So somebody that's processing that data on your behalf as opposed to for their own purposes. And the updates kind of cleaned that up and changed third party to service providers. So what that means is your privacy policy has to actually outline the categories of service providers that you're using. That's a fairly common thing we see, if nothing else, as examples. Maybe they're not comprehensive, so maybe there's some work to do there to go back and actually come up with some categories that we feel like are comprehensive, but that is an explicit requirement from the California regs, so something to look at. The third sub-bullet there is what Josh just talked about in Rhode Island. So the website has to disclose these third parties to whom you sell or may sell personal information. They define sell very broadly. So this is kind of like California would include your online ad tech data collection tools. So that could be, for example, pixels, etc. So we'll need a way to do that. It's a little bit challenging, especially in that context, because those change frequently. So the two main strategies we've seen companies take, or at least start to consider as they're working towards this, is to update their cookie tool. So they'll have the categories of cookies, and I use cookies broadly here to really discuss any type of online data collection tool. But then you can kind of expand the category and there might be a list underneath it. That's something that you commonly saw for websites used in other jurisdictions like Europe. The other practice that we've seen is just a link in your privacy policy that instead of taking you to the tool, takes you to a static page that they can update with the names of these ad tech companies. So it's challenging. I think everybody's kind of struggling with this a little bit right now, but something that Rhode Island already requires, and so something you should be thinking about if you haven't yet. I'm going to kind of go through these others quickly, just in the interest of time, but right to limit, and I'm sorry, the right to know and access. Some of the legacy privacy policies limited that right to just 2 times per 12 months. That came from California law, but a bunch of states actually do not limit the number of requests consumers can make. And Oregon has actually called that out in privacy policies and some of the enforcement actions that we've seen. So you want to go back and make sure that you're not limiting that to any number of requests. If you start to see an excessive number from a single consumer, those other states do allow you to charge your actual costs for processing those. So probably not the first one, probably not the second one, but if you start to get a bunch in a calendar year, you can do that. But just make sure your privacy policy is not limiting the number. The other thing is that certain states, in addition to the categories of third parties, you have to provide the names of them in response to a right to know request. Based on the Rhode Island requirement that we just talked about, this is going to be kind of interesting because you may be able to just point to your privacy policy, which already have the names as part of your right to know. But just know that Minnesota, Oregon, Connecticut, they do have this specific requirement. It is more onerous than California or these other states that focused on providing categories in response to those requests. California has a legacy privacy law that's been around for a long, long time. It's called Shine the Light. It really allows consumers to do two things. One, to ask for the names of third parties to whom you disclose their information for direct marketing purposes. The other is to opt out of those types of disclosures. So as you can see, there's a lot of commonality between that and the more modern CCPA type of requests. But the difference is China Light has a private right of action. And so what we're seeing is the plaintiffs bar send notices to companies asking for the information, and those companies that do not respond by either providing them information or explaining that they can opt out by using the information in the privacy policy, they sue them. And so what we've recommended is to add a shine the light provision back to your privacy policy if it's not in there already, and basically saying if you want to opt out, just use our do not sell form. That way it's kind of merging that concept with your already existing do not sell procedures. And if you ever get any notifications, you can just point them in that direction and avoid a claim. The other item that came from Oregon is a lot of privacy policy said, we may make changes, they're retroactive, keep checking back frequently, et cetera. You actually are required under most state laws to get consent to use previously acquired information for new purposes. And Oregon's position is that not only do you have to get that consent, but that your privacy policy should reflect that requirement as opposed to saying that you can use previously acquired information for new purposes. So a tweak there. Um, the other thing listed at the bottom is that California and its updated regulations specified that every page of your website has to have a link to the privacy policy and that all mobile applications within their settings menu should also link to the privacy policy. So those are clarifications of, quite frankly, rules that have kind of already been around, but they address them a little bit more directly and specifically.
Yeah, Nick, before we move off of privacy policies, we got our first question,
Okay.
which is, does identifying the third parties you sell to for Rhode Island violate client contracts?
I suppose it depends on the contract. I mean, I think again, a lot of companies, what's going to be the bulk of this is going to be the um, these online ad tech type of companies. But for those that are also selling PI offline, for example, maybe it's a marketing partner, maybe you're a lead generator and you're selling information to clients, or you're just a data broker in general. Those contracts I could see perhaps having that level of confidentiality, but I don't think a confidentiality provision overrides a legal requirement. And so, I get that there is that issue. Your contract probably also requires you to comply with all applicable laws. So, given these new legal requirements, I think you're probably in a position where you need to make that disclosure, or at least make some risk-based decisions as if you're not going to do that.
Mhm.
In terms of other notices, so the privacy policy is the main one, but there are other notices that are required. California has this concept of notice at collection. So this is at or before the time you're collecting somebody's information. The clarifications here largely just mirror what we just talked about. So every page of your website has to have a link, and the mobile application should also link to this. So typically what we see is you have a privacy policy or a privacy notice, and then you have a California specific privacy policy or notice. Some companies combine them into one document. If you do that, the California part has to be a dedicated section, and what has to go in there is largely duplicative of what's in a privacy policy. So we generally prefer those to be separate and have separate links, but there is some flexibility on that. These other two notices, these are California specific notices as well. Really, I think the one point I want to get across here is that when you're providing or when you're collecting information, what they're really trying to do is have you provide just-in-time notices. So, for example, this opt-out of sharing and sales and sharing notice, they're saying that if you are collecting through a connected device, so this is probably not all businesses, but if you are collecting through connected devices, you have to provide the notice through that device. And similarly, when you're collecting sensitive personal information, if you use that information for purposes that require a right to limit, um, then you have to provide notice of that right through that same manner. So again, just throwing these notices in your privacy policy and not making them more visible to consumers in a kind of a just-in-time manner is not going to be sufficient. And so again, I think those two notices impact a smaller number of businesses. So I'm not gonna spend a lot of time on that, but just understand if you are required to provide these notices, you should think about where to put them so that consumers are seeing them through the same means in which you're collecting the data. So pivoting a little bit, we're still on the website. Now we're going to talk a little bit about cookie issues. Kind of these top ones largely stem from the new California regulations. So you're required and have been required for a long time to accept global privacy control signals. And for those of you that are not familiar with that, essentially what that is a setting on the consumer's browser or browser extension that tells every website that they visit, I want to opt out of sales and sharing. And so if your website has a cookie tool, most of those cookie tools will be able to accept and process global privacy control signals. And you can generally determine what that means. So for example, I can say, if I get this signal, I'm going to opt them out of advertising cookies and analytics cookies, et cetera. There's also a requirement, and there has been a requirement for a while to take that GPC signal for a known consumer. So think about a logged in customer on your website. Now, instead of just this is an anonymous user of the website, you know that user is Nick, for example. So what you're required to do is not only opt me out of these online tools that qualify as sales and sharing scenarios, but actually place a do not sell share flag in the customer database in my record, so that if you engage in any other types of sales or sharing, you opt me out, right? So again, this is an issue just for known users. Typically, that means logged in users. That requirement has been there for a while too, right? So these requirements have been there for a while in the regulations. What they've done with the recent updates is two things. The first is before the regulation said that when you get a GPC signal, the website may display that you've processed and honored that signal. They changed that may to must. So now your website must actually have some type of indicator saying that we've received and processed your opt-out signal. That's typically also a setting within your cookie tool. So if you have that, you're using OneTrust or one of these other pretty prominent cookie tools, that should be something that you can easily do through that tool. And you want to make sure that that's turned on. The other thing that they did is we talked about the concept of taking a GPC signal and applying that kind of in a customer database such that you can honor it for offline disclosures. The regulations now address kind of the inverse of that. So let's say I go to your website, I make a do not sell request using not a GPC signal, but I go to the form. I go to the form and say, I would like to opt out of sales and sharing. You then process that. You probably put a flag in my account in your customer database, and you've opted me out of probably your offline sales and sharing scenarios. What the regulations are saying now is if I am a website user and you can identify me, again, a logged in user being the most obvious example, you have to automatically opt me out of those online tools that are sales and sharing. So again, I've never actually toggled anything on the cookie tool. I did not send a GPC signal, but I do have a do not sell share flag in my account. Once I log in and you can recognize me, it should kind of ping that account or your database, see if that flag is there. And if it is, automatically opt me out of these sales and sharing tools. So there's a lot there. I'm sure there's going to be questions on that. I don't want to spend any more time just because we've got a lot of content. This is a real challenge for a lot of our clients because it requires integration between your customer database and your tool. I think the GPC one is something that people had been working on because of the existing requirement, but perhaps hadn't been working on the opposite direction. But it is something that you need to be thinking about now if you haven't already. The other issue on the cookie tool issues that we wanted to highlight for everybody is when we see enforcement and we see kind of lawsuits or claims, oftentimes it seems like what the underlying issue is, perhaps you didn't properly categorize your cookies. Perhaps when people are thinking about cookies, they actually truly are limiting that to, what an actual cookie is and not thinking about that as the shorthand term used for pixels, beacons, and all other types of data collection tools, right? And at the end of the day, that's really what we're talking about, are all of these automatic data collection tools. So you need to make sure that when you're categorizing and you're doing opt-outs, you're applying it to all of these tools, not just what is truly technically a cookie as you think of it from an IT perspective. The other thing that's coming up more increasingly is companies implement their tools, they work properly at the time, they forget about it, they don't go back and audit them or check them, and then later there was something that broke down. And the reasons for that could be varied, but regardless, somebody is toggling off these types of cookies, yet they continue to fire or continue to collect data. And so what we're seeing is actually plaintiffs' attorneys literally just going website to website, toggling off certain types of data collection tools, and then running scans to see if the website is actually responding to those. And if they detect tools that they feel are inconsistent with their choices, they will either sue you or they'll send you a claim and you'll have to deal with that. We're seeing that with increasing frequency because it's a very easy thing for them to do. And it's not just necessarily a privacy issue. I think there's some potential risk under consumer protection laws because you've essentially said, I've opted you out when you haven't. So there's a deception issue there, which creates quite a bit of risk under consumer protection laws that have private rights of action and statutory damages and those types of things. All right. The other issue that I want to mention, we're kind of still in this online world right now, relates to dark patterns. And so, that's a term that's been around forever. This is not new. There's been guidance out there for a long time about certain things that you should try to avoid. We just talked about the cookie tool. So one of the ones that's been out there for a long time is when you have options, you should not have an accept all button on your cookie banner if you don't also have a reject all button, right? So if you have to have symmetry of choice is what they call it. So accept all and then manage preferences or something like that is not sufficient in the eyes of the regulators. What they've now done is kind of added some additional examples like that. And the one that I thought was interesting relates to having two options, but one has a more eye-catching color. So let's say you did have those two buttons, accept all and decline all. Oftentimes what we've seen is the accept all is maybe like blue. It's drawing attention to it's bright. And then the decline all might be gray or white or something like that. According to California, that is an impermissible dark pattern. So again, you need to go back, look at your tools. It's not just a cookie tool. This could be any other type of privacy choices that you're providing to customers, but that was just one example I thought was pretty common and pretty standard in industry. They also have clarified that if you have a kind of a binary toggle on and off, it needs to be very clear what on means and what off means. So apparently they've gone through and they found that certain privacy choices are confusing as to what it on actually means and what off actually means. And there's some double negatives and things like that in there. And so I haven't personally noticed this as being as much of an issue with the clients that we've worked with, but something to think about is when I click on, is it really clear what that means, what is on and what is off? The last two bullets here really stem from a clarification in California that says you can't require consumers to submit a new request for submit a separate request for each of the privacy rights that they want to exercise. So when CCPA first came out, some of the web forms we saw, basically you would select, is this a right to know? Is this deletion, correction, opting out of sales, etc.? But you'd have to submit a separate request for each of those. California is saying you can't do that. So in our mind, what that means is you should either have one form or perhaps two forms. And the reason we say two is because there are different rules around verifying the identity of the consumer for right to know, deletion, and correction, as opposed to opt-outs and requests to limit use of sensitive PI and soon opting out of automated decision-making technologies. Those opt-outs, you're not allowed to verify a consumer's identity. The other ones, you're required to verify their identity. And so you typically need to collect more information to do that. And probably, quite frankly, you need some additional procedures in place on the back end after you've asked for certain information to verify their identity. So again, in our mind, maybe having a bifurcated form where the verification rights are all lumped together and the non-verification rights are all lumped together, I think that would be fine. But anything more than that, I think you're running into issues. And we've seen this with California already, and it's something in terms of enforcement, and it's something that they've specifically addressed in their regulations. And so we just encourage you to make sure that your form doesn't require a separate request for each type. If you lump them all together, though, you need to be very careful about what you are requiring the consumer to provide. So the clients that we've worked with that have one form, what we've recommended is have that be dynamic. If the only request I'm submitting is an opt-out request, the fields that are required as indicated with an asterisk should be very limited based on like, what do you need to find their record and apply the opt-out? That's it. Whereas if they check maybe the opt out plus a request to know, at that point in time, you can require them to provide more information because at that point in time, it's permissible because you have to verify for the right to know request. So I know there's a lot there, but just again, think about these types of things, go through the regulations. We can help as needed and really just make sure that you're meeting these technical requirements. It is something that these states and California in particular care a lot about, and their enforcement shows that, substantial compliance is not always good enough for California.
Mhm.
And while we're talking about privacy requests, I'm going to turn it back over to Josh to kind of talk about some of the updates to the actual substantive requests themselves.
Yeah, so let's move from the website into the office, right? What do we actually need to do in response to some of these requests, and how has that changed? And most of what we're going to talk about on this slide and the next slide come from the California regulation changes that recently came out. Let's start with right to know, right? This is when a consumer is asking to receive the personal information that you have on file. Regulations have made clear that the business should provide the consumer all the information the business maintains about that consumer, not just information collected in, say, the previous 12 months. There had been kind of some chatter amongst folks and some ambiguity in the regulations and the laws about, okay, what is the time frame that this right to know request really requires a response to? And what they're making clear now is if you still have the information, if it's still sitting in your systems, if you can access it, then that needs to be turned over to the consumer. They also clarified um, that those right to know reports, which, if you remember in California, there are two flavors. There's a what you might call a categories report, which just explains to the consumer the types of personal information that the business maintains. And then there's a specific personal information report where you actually give them the personal information that you have on file about them. In either instance, under the regulations, those reports are supposed to include some additional background information, which is a lot like what you see in the privacy policy that talks about the uses of information, things like that. The regulations have clarified that in that kind of background information, we need to include the categories of service providers and contractors to whom we have disclosed that consumer's PI. And this is similar to an issue in the next bullet about disclosing for a handful of states third parties to whom you've disclosed the consumer's PI, except it's a categories based instead of a name based. And I do think that there's a possibility, with this service provider one, that we can, sort of like with the privacy policy, perhaps use a list that is a little bit broader than maybe we have provided for that exact consumer. But what I really want to highlight with this one is this goes to an issue that we see across a lot of businesses, which is a comprehensive data map. How do you track where the data is coming from, where it's going, and not just on a holistic, well, this system talks to this system basis, but actually for individual specific consumers, right? What is the tracking? What is the logging that we maintain for how, Josh Stevens's data is moving through our systems? And we're seeing regulators pushing more and more for being able to honor privacy rights, maintain logs, explain things to consumers and to regulators on that individual consumer basis, where that type of logging and tracking is really critical. So, as you're thinking about your product roadmaps and your IT architecture as you move forward, think about building in that comprehensive data mapping and then also a program and a process for logging and tracking individual consumer data. Now, going to the third bullet point here under right to know, this is what Nick mentioned before about about the right of consumers in Minnesota, Oregon, and Connecticut to receive a list of the third parties to whom their information was disclosed for Minnesota and Oregon or sold for Connecticut. And there are two things worth calling out here. First is notice the difference in the words disclosed and sold. The Connecticut requirement is narrower because it is based solely on a sale. But the disclosure requirement could theoretically capture something like turning over information in response to a subpoena or as part of a regulatory filing or some other disclosure to a third party, not your service provider, not your data processor, but a third party that isn't really a sale. So keep that in mind because that does expand the breadth.
Just,
The
I'm just going to interject real quick because I've actually talked with an assistant attorney general in Oregon about that and asked that question, and she wasn't she found the question very interesting and she acknowledged the breadth of the language disclosure. She said that personally, this is just her take, not for, she's not speaking for the agency as a whole. She was more concerned about seeing information that's more commercial in nature. So if you're providing it in connection with like a lawsuit or a subpoena response or something like that, they didn't care as much about that. So I think all businesses are just going to really have to come up with like what type of how conservative or risk tolerant are they going to be? But I was at least somewhat encouraged by that very informal interaction with them. Certainly, I don't think we can foreclose the possibility that others aren't so accommodating, but that was at least some level of flexibility that regulators don't always
Mhm.
give. So I guess that was good.
Yeah, no, and that's a great insight. And the other thing to point out is the Minnesota and Oregon requirements are slightly different from each other. The Oregon requirement is that the business can choose whether to give a list of the specific consumers, the disclosures for that specific consumer, or a list of all disclosures that they make for all consumers. And in Minnesota, you have to give that consumer specific list unless that is not possible, and then you can give the more generalized list. So that's another kind of little nuance between the two laws that is worth considering. Then moving to the right to correct, one of the biggest issues that we have seen, and the regulations now are coming up to meet this, is once you correct incorrect information, it needs to stay corrected. And so a business needs to have a process to prevent recollecting incorrect PI. Where we see this issue come up most often is when businesses purchase data from a data broker or receive data from some other third-party source and then overwrite consumer-provided data with that third-party data. That's where we see this issue come up most often. So just in your processes, that's something to think about is once you correct a piece of incorrect data, how do you make sure it stays corrected? The second component is if if you do fix data and that data came from someone other than the consumer, then you're required to inform the consumer about where that incorrect data came from, or you need to go to the source of that data and let them know that that data was incorrect so they can correct it on their end. So it's now creating this little additional obligation to help that consumer get that data corrected with whatever the source of it was. And lastly, with right to correct, this also kind of bleeds into right to know as well. You're not supposed to turn over to a consumer some highly sensitive information. The example we always use is social security number. You're really not supposed to turn that over to a consumer in a right to know report. In fact, depending on the state, some states outright prohibit that, right? You cannot turn that over. But the consumer still needs a way to make sure that information is accurate. And the California regulations now have introduced this idea of giving the consumer the ability, for example, to say, call in to the business. The consumer could tell the agent what the information should be, and then the agent could confirm whether that is or is not the information on file. And that way, the consumer is able to make sure that the highly sensitive information is accurate without running that risk of the business turning it over to someone where there could be identity theft. Moving on then to the right to limit use of sensitive PI, there's kind of a new concept for both this and the do not sell share rights, but I personally think this really should extend to all rights, which is a consumer should have the ability to contact the business and confirm that their request was processed. This is just a customer service function, right? Being able for a customer service rep, let's say, to be able to look and see, yep, we got your request. Yeah, it looks like it's still in process or it's been completed. Here's the date it was completed. That way, consumers can get assurance that their request was complete, even if, say, they lost that letter or that email that told them that it was complete. The other highlight here, if you're going to give consumers the right to override a prior limit use of sensitive PI request, that needs to be a two-step process, essentially an opt-in and then a confirmation, similar to the process that's used to override a prior do not sell share request. We don't really have any clients at this point who are giving consumers the right or the ability to override a prior limit use of sensitive PI request. But if that ever happens, then we do need to have that two-step process.
The only exception to that might be those that are collecting precise geolocation data, and
That's possible. Yeah.
maybe there's a toggle for that kind of on off. And so if we're reading this very strictly, if you've turned it off and you're trying to turn it back on, there should be kind of a button to click and another to confirm type of
Yeah.
thing. So that's maybe the one example. But for things that are more like demographic information that's sensitive, like race or ethnicity or religion, those types of things. We're not really seeing that in terms of providing, consents because it's just unlikely that anybody would ever provide that type of consent.
Yeah. And lastly, Nick already mentioned it, so I'm not going to go into the detail on it, but don't collect more information than necessary to process the consumer's request. This has been California has made this very clear.
Right,
over,
and
over
don't
2020.
require verification for those opt-out and limitation requests, like I mentioned as well. So
Yeah. Yeah. All right. So staying in the back office, let's talk security, Nick.
yeah, so I think the biggest things that came out of we've this to this point we've talked a lot about kind of the nuances that have come out of California's updated regulations. So kind of tweaks to some of the rules that were already there. In addition to that, they adopted expansive regulations on three key topics. Cybersecurity audits being one, risk assessments, which are kind of that's the term California uses, are really what you might think of as a data privacy impact assessments or privacy impact assessment. And then the third relate to the automated decision-making technologies. I suspect that we will have one, perhaps multiple additional webinars to cover these topics because they are so in depth and some of the requirements, most of them are not yet in effect. For now, I think what we're going to try to do is just kind of acknowledge their existence and talk about them at a very, very high level. So, more to come on these, but for now, we're going to go through kind of jumping in with the cybersecurity audit requirements first. So, the triggering activity is a business that processes personal information in a way that presents significant risk to consumers. And they essentially define that to require certain types of thresholds. So the first is if you're deriving over 50% of your annual revenue from selling or sharing PI in the prior calendar year, then you're automatically subject to these rules. That's considered significant risk to consumers, and therefore you're in scope. The other way that you can become subject to these rules is a combination of things. So the first is that you have annual gross revenue of a certain amount. Right now, that amounts 26 million and change. That's also the revenue threshold for CCPA applicability. Now, remember, revenue threshold is just one of the potential thresholds for applicability, but the number is the same here. But for these cybersecurity audits, it's that plus something. So it's that plus one of these two things. You're either processing 250,000 California consumers or households information, or you're processing 50,000 consumers information, sensitive personal information. So again, it's annual revenue plus this. So it's going to be kind of what Josh said, start at the beginning. One of the things we always do is look at applicability of requirements. And so this is something that you should do sooner than later. The requirements don't kick in until sometime between 2028 and 2030, depending on your size. So the largest companies will have to comply by 2028. And it gets staggered as the businesses get smaller from there. So again, super high level. The main takeaway here is these exist. There are specific requirements. You're going to be required to submit a certificate of completion to the state. These have to be independent audits that can either be a third party or they can be internal, but if they're internal, you have to meet certain standards. We're not going to get into the weeds of kind of what it has to cover, what's the depth. If I'm already doing certain types of like ISO or NIST types of audits, is that enough, right? Those are good questions. We'll probably address that at some future date. But for now, just understand that these exist and that they're coming. Moving from the cybersecurity audits to the risk assessments, again, these are kind of DPIA types of things. Here's a list of the triggering activities. A lot of these mirror what you see in other states and for requirements that are already in effect. So, most states, if you're selling or sharing PI, that triggers a risk assessment. Or if you're processing sensitive PI, if you're other states use the term profiling, but if you're using automated decision-making technologies or conducting profiling for significant decisions, those are things that are going to trigger requirements in most states, and including California. California has a couple of nuances, like this profiling based on sensitive locations and training these automated decision-making technologies for the purpose of making significant decisions and biometric use cases. So there are some kind of nuances that are California specific, but a lot of the other ones are already in existence today. The significant decisions, the profiling or ADMT, if you're kind of curious what that might be, typically what this means is it's going to produce something that is used to justify the provision or denial of specific types of goods or services. So this would be like financial goods or services, housing, education opportunities, employment opportunities, healthcare services, or other essential goods or services in many states. So that's kind of what we're talking about here. For a lot of businesses, you might be using profiling to target an audience for a marketing campaign. That's not what we're talking about. We're talking about something that's a little bit more significant than that, but something that you should look at to make sure that your profiling activities do or don't trigger these requirements. So again, that's kind of like what activities trigger them. There's a couple of interesting things about California specifically. So under the California regulations, they specify that your employees who have job responsibilities that involve the activities that we just discussed, they have to actively participate in the assessment. This can't be something that is done entirely by a compliance team or a legal team. That kind of makes sense. I mean, I think this has kind of been implied all along. And Colorado's regulations may even have similar requirements. I can't remember exactly, but bottom line, you're not going to be able to do a meaningful assessment unless you have input from the stakeholders who are responsible for those activities. The other one is that you actually have to submit these to the state of California. So in other states, you have to keep records of these and provide them upon request. California eventually will have a requirement to submit these to the state once a year, and it has to be submitted by an executive who has responsibility, sufficient knowledge, and the authority to do this. So really, again, the goal here from California is pretty clear. that this has to be something that is not only actively engaged in by stakeholders, but then reviewed, confirmed, and signed off on by an executive level person. So that is kind of unique. Um, the timeline for these, it's not listed on the slide, but I think it's important to just note quickly in terms of this assessments themselves. So there's kind of two timelines. One is when do I have to submit these, and the other is when do I actually have to conduct them. So in terms of the actual conducting of the assessments, if you have an activity that began prior to this year, so let's say, for example, you were doing targeted advertising, and that started in 2025 or before, the California regulations say that you have to document your risk assessments by the end of 2027. So there's a little bit of a grace period there. For any new activities that start in this year or later, you have to do it before engaging that activity. So let's say all of a sudden you're going to start selling PI when you didn't before, or you're going to, start doing target advertising, you hadn't done that before, or you're going to materially change the way in which you're doing it. At that point in time, you have to actually conduct the assessment and document it before engaging in those activities. So this is something that's partially required today, even in California. In terms of submitting them to the state, the first deadline is not until 2028. So that is going to cover all of the assessments that you do this year or next year. You'll submit by April of 2028, and then it'll be a rolling, 1-year basis. So the assessments you do in 2028, you'll submit by April 1st of 2029. So again, there's kind of a cadence here and something that hopefully you're doing these already. If you're not, and you're engaging the activities that trigger them, you should be because of the other states, and you should do it. You should make sure that what you've done also covers the California requirements. The regulations have a lot of specificity as to what types of things you're supposed to be thinking about and documenting. And there's a lot of overlap with the Colorado regulations that have a lot of specificity as well, but you just want to make sure that you're capturing any California specific nuances. And with that, I'm going to turn it back over to Josh to get into a few other items related to kind of state specific nuances and some other issues.
Yeah, so here in our last few minutes, these are kind of the grab bag of random items to call out. The first is Oregon. HB 2008, which came into effect on January 1st, prohibits data controllers from using data for targeted advertising or profiling with legal or similarly significant impacts if a consumer is under the age of 16. It also prohibits selling personal data of consumers under 16, as well as precise geolocation data. And so this is the first time that we have seen a state straight up outlaw the sale of a particular type of data. And that's an interesting change. It'll be curious to see if other states follow suit. But if you engage in sales or if you process data of consumers under 16, this is something to watch out for from Oregon.
Oh.
Continuing with data sales, data brokering is always a hot topic. And one of the things that I've noticed is a lot of companies don't exactly understand what it means to broker data. And the definitions in California and Texas in particular are broader than you'd think. So, for example, in California, even if you collected information directly from the consumer that you're now selling, if you haven't engaged with that consumer in the last 3 years, then that could be a brokering activity. It's not just because you're selling data that you didn't collect directly from the consumer. And in Texas, they've got this interesting wording around collecting, processing, or transferring personal information. You'll see here on the screen there are some thresholds, but that's also a bit of a broader concept than just a traditional sale. And so it's important if you engage in any type of data sale activity to think about whether that could be a data broker activity and do that analysis of whether these laws apply to you. Because enforcement under the data broker laws is real, it is happening. California especially has been aggressive in this space. Most recently, these were the two most recent ones. Rickenbacker Data, also known as Data Masters, paid a $45,000 penalty and agreed to stop selling personal information of Californians. That's a big state to have to stop selling personal information from. And then S&P Global, massive company in this space, 62,000 plus dollar penalty. Essentially, what they said was we had a mistake, an administrative error that caused our registration to not be in place. And so they were required, as part of their settlement, to adopt procedures and audit processes to prevent that from happening again. The
Josh, just jump in real quick. Those dollar amounts, for a lot of businesses, they're not nothing, but they might seem fairly low. Remember that these are per day violations. So every
Mhm.
day that you're not registered, it racks up pretty quickly. So if you were supposed to have been registered for several years, it does add up pretty quickly. So don't be fooled by, the relatively modest settlement amounts there.
Yeah, yeah, that's a good call out. The other thing is in California, if you are a registered data broker, you're going to be required to participate in the drop system. This allows California consumers to make one deletion request to the state that is pushed out to all data brokers. And then the data brokers also have to feed fulfillment information back into this system. It is open for registration by consumers and for data brokers to start getting connected with it. Integration is required by August 1st, and I saw a report this morning there are over 100,000 California consumers who have already signed up for this system. And so if you are a data broker registered in California, you need to get this done by August 1st and be prepared for a deluge of deletion requests that are going to come in through it. Next up is AI. I think we'll probably do an AI specific webinar this year because this is such a hot topic. I'm really not going to go into much detail. Just see here on the screen, we are seeing AI specific laws popping up across the country. California California and Colorado are probably the two that are most at the top of people's minds at the moment. These laws vary in applicability, but generally apply to developers and deployers or one or the other. So, depending on where you sit, you may have obligations depending on the law. High risk systems, so those that are sort of like Nick said about the risk assessments, right, that are making decisions around employment, financing, healthcare, et cetera. Those are the more highly regulated, as well as what are considered these large foundational models. Think like ChatGPT, right? These really big models. And you can see some common requirements on the screen here for deployers. Like I said, we're not going to really get into this today, but we'll probably do a webinar on this soon because it is a growing topic.
All right, and just in time, this is our last substantive slide as we're approaching the top of the hour. But just in terms of enforcement, as you might expect, California is very active. In addition to all those data broker enforcements, Josh just cited two. There's been many more than that. They have also engaged with a wide range of companies in terms of what industries they're in. What we found is while it might be a specific issue or complaint that kind of starts their inquiry or investigation, once they're in there, they being the California Privacy Protection Agency, they're going to look at everything. And California is also unique in that you have that privacy agency, but you still have the AG also doing its own enforcement. So there's two regulators that are both very active. Um, Texas seems to be looking for kind of splash headlines, and so they seem to largely be focused on large businesses. So here's some of the examples listed on the slide. I'm not going to go through all of them. They're bringing enforcement under both their newer privacy law, but a lot of these actually, because the activities predated that privacy law, they're also bringing privacy actions under their consumer protection law. So if you did something that they felt like was unfair or deceptive, they'll bring a claim that way, which is traditionally how states have enforced privacy laws for the past several decades when there wasn't an actual specific comprehensive privacy law within that state. So again, I don't want to say that if you're not a large business, you are fine in Texas, but again, they seem to be looking for splash headlines. Oregon has been quite active. They issued a report talking about all the investigations that they closed. It doesn't get into how many investigations are currently ongoing. They had a right to cure period, so a lot of their investigations closed without any type of penalty or significant settlement. And again, that's largely due to the cure period. That has expired now. So I would expect that at some point will be more substantive settlements. Um, they seem to be fairly nitpicky about, their nuances and making sure that you're complying with things that are slightly different in Oregon than maybe in California or Colorado or other states. So think about that. They've given feedback again on privacy policies and privacy rights and updating your privacy policies and kind of like, again, the more technical things. Our experience thus far with their regulators has been fairly um, amicable. And they seem, again, fairly willing to work with companies, but I think it's way too premature to see how things are going to shape up once now that the cure period has expired. Several states have started joining forces for specific issues. So, for example, these three states listed here, California, Colorado, and Connecticut, have joined forces to investigate, the degree to which businesses and websites are accepting and processing those GPC signals that we talked about earlier. Other states have right to cures that may be coming to expire or just never had any to begin with. So we really expect state enforcement to continue to grow as they start to get larger budgets, as companies have had time to comply with these laws. And as I mentioned earlier, we're also seeing an expansion of private claims related to some type of privacy activity. Things that are public facing are the most obvious. So, cookies, whether your cookie tool is working properly, those types of things. But I don't think that the scope is limited to just those. Those are just the most obvious examples. So with that, we're pretty much out of time, maybe even a minute or two over. Appreciate everybody attending today. We will make this available on our website. Josh, do we know how long that's going to take?
It'll probably be up next week.
Okay. So next week we should probably have a copy of this up. We happy to answer any questions that anybody has, but for now we really appreciate it and everybody have a great day.